I want to have one more go, if I may, at why we say it's important that you have the Murphy statement. Well, the court's expressed some doubt about that, and it's quite important that you should appreciate at least our submission as to why it's important. The court, of course, has to judge the compatibility of legislation in accordance with the effects of the legislation. The effects of the legislation are a matter for the court, because they're questions of interpretation. But the justification for the legislation, from a compatibility with the convention perspective, the responsibility for arguing that invariably falls on government. Parliament doesn't come in and defend its own legislation. That task falls to government. And it's unsurprising, perhaps, that it does so, because no piece of legislation ever makes it as a bill into the parliamentary process unless the justification for it, the lines that it's proposed that it should draw, the exceptions that it's proposed that it should make, have been thought through from a policy perspective by the relevant government department or departments. In Strasbourg terms, of course, it doesn't make any difference, that divide between the executive and the legislature. It's the government that has to justify it. Moreover, justification is a current question. It's a question for the court to consider as of now. And the consequence of that is not merely that it allows for evidence going to matters that post-date enactment, which can be relevant to justification, because the justification is a current game as of now before the court. But it also indicates that when you're coming to consider things like what was the legitimate aim, I mean, it may well be that that's self-evident from the face of some of the provisions of the Act, it may well not be. Some of the detail of that may well be within the departmental knowledge. When you're arguing about whether there were less intrusive measures that could have been done. Again, the explanation for why one route was gone down rather than another, which may well depend upon policy judgments at the stage of drafting the bill, that again is a matter that the government is uniquely well placed to make. So these statements, for this purpose, are fundamentally different, we submit, from the sort of strictures that limit the admissibility / relevance of some types of evidence from government about the meaning of legislation. And it's for that reason that I'm going to continue, if I may, to give you references in the Murphy statement. I don't expect to sound too preachy, but it is quite important because it's obviously an issue of general principled approach as to how you go about looking at these things from a convention perspective. My lords, I was on legitimate aim being accepted, but its nature bearing emphasis. And I've made the point that there was a development, as one sees from the Murphy statement, of the scale and nature of the issues. It wasn't just a kind of one-off, here we are. It was a progressive appreciation of the scale of the problem, or the problems that needed to be fixed. And they extended from cladding and the immediate worries about the aftermath of Grenfell, where it was evident, at least in headline terms, what had happened, but through to more detailed appreciation of the things that had led to the number and scale of deaths in that tragedy. Including the undermining of the safety assumption that everyone just stays in their flat and that's the way buildings have been designed, through to inspections of buildings as time went on for cladding purposes, but also with an eye well open to other possible structural fire safety defects within these sorts of buildings. And that raised a whole series of further problems. And all of those things contribute, therefore, ultimately, to the scale of the cost that would be needed to fix those issues. And the sums of remediation of all of those problems were and are enormous. Mr. Murphy has given you in paragraphs 28 to 30 some of the headline numbers, but perhaps the only one really needs, because the detail is not so much important as the headline number. And the headline number on current estimates is that if you wanted to fix simply the unsafe cladding, and there were problems beyond that, on all of the buildings over 11 metres in England, geographically limited in that way, the number was probably somewhere about £16.6 billion, with a range, unsurprisingly because costs are uncertain, between 12.6 and 22.4 billion pounds. So an enormous sum of money that needed to be found to fix all of the problems. I mentioned some of the problems beyond mere cladding earlier. You find other aspects that needed to be dealt with being set out in Mr Murphy's statement between 38 and 42. Interim measures, very expensive for obvious reasons. People actually sitting awake in these buildings, seeing whether there were fires. All of that expensive. Fire safety mitigations in the short term, see 38 to 42, and legal and other costs, which is our direct context here, associated with all of that. And what that led to was a distribution, or a who pays problem, as it was put by Mr Murphy. And a clear summary, it might be thought, of the basic societal and fairness issues to which that gave rise is set out in 3 paragraphs of Mr Murphy's statement, 48, 49 and 50. Again, all of that, I'm sure, my lords will say, well, that's all well understood, particularly the points in 48. But you see the justification or the problems that might flow if you just simply left the position with leaseholders having to pay for remediation-related costs dealt with specifically in paragraph 50. They weren't responsible. Many of them couldn't afford to meet the costs. So either the buildings would be left unremediated and unsafe. Thirdly, those who were responsible for creating the defects, in many cases, who made considerable profits on defective construction work, were not contributing to the cost of remediation. That is then picked up and dealt with specifically in further paragraphs a bit later on in the statement, including in particular from paragraphs 64 to 101, that long section, setting out and considering why it was thought necessary for there to be extensive statutory protections for leaseholders. And you see that in particular as one paragraph within that block that is of particular importance. It might be thought to be paragraph 66. So that's what, in broad terms, needed to be done, or needed to be thought about. The second of the points I make, the key points on the justification, is that Parliament then decided, having been presented by the department, as it were, with the bill and then the amendments, it then decided in effect that that burden did indeed need to be shared. And not merely shared, but removed from the shoulders of leaseholders. The aim, as it's put in paragraph 97 of the Murphy statement, was an equitable redistribution of liability across the system. And the headline sums are set out. The government, as you see from, you go back in the statement to paragraphs 51 and 52, and you'll see an answer to a question I think my Lord Justice Newey raised with me earlier on, which is, did everyone know that that the government was going to be chipping in from an early date? 51 gives you the answer to that, they did. But ultimately, from 51 and 52, you get the headline point, which is that £5.1 billion have been committed by the government. And the government, of course, means committed on behalf of and funded by the taxpayer to fix the problems. Now, I can perfectly happily say in social justice terms, quite right too, because some of the findings by Lord Justice Morbeck and Sir Martin Morbeck in the Grenfell reports indicate that there were widespread failures in the regulatory systems, for which it might be thought there is broad responsibility on the shoulders of government. But the public have borne and will continue to bear a very significant part of those rectification costs, from which they will derive, of course, no benefit, other than the safety, of course, of those who sit within the buildings. Industry has also pitched in, as it were. The forecast, I think, is 3.4 billion plus 3.4 billion. That's paragraph 100B and C. I've checked whether B and C are pluses or whether they're saying the same thing, and I think they are pluses. So it's 6.8 from industry and developers. But you will have noted from the legislation that even where the burden has moved from landlords, from leaseholders to landlords, there is still the possibility in some cases of recouping, there is still some sharing, there are still lines to be drawn. And still within the legislative scheme as an integral part of it, opening up more broadly the ability to go after those who might be thought actually to bear primary responsibility or a critical part of the responsibility for the failings, the manufacturers and all of that. So there are provisions dealing with the expanding limitation period, the expansions in the ability of people trying to recoup the costs if they've had to bear them initially, by swerving, if that's the right way of putting it, past the special purpose vehicles that are traditionally used by developers. And of course, if you could only go after the company that was responsible for the development, you might well end up with an insolvent company and therefore no ability to recoup. So all of those are part of the social justice balancing. And an important element of that, emphasised by Mr Murphy, paragraph 98, the basic idea that those with broader shoulders should contribute most. So that's the second point, the sharing of the burden, all the intricate matters that are set out in the legislation from that perspective.
You said earlier on that the burden was lifted from leaseholders generally, but it was rather more nuanced than that. I mean, the paragraph 2 applies to leaseholders generally if the defect is one for which the landlord is responsible.
Yes.
And then 3 to 9, you have to be a qualifying lessee or leaseholder. And in some circumstances, if it's otherwise payable, there are caps, so you still pay.
There are.
Then that varies according to the value of your property. You may end up spending having to be paying up to 100,000.
My lord, I'm sorry, I didn't want to oversimplify. So you are, of course, right. It's not a total lifting, as it were.
No.
But the drive was to take it away from it simply being a burden which is entirely transferable onto leaseholders.
Well, no one suggests those distinctions as between different leaseholders is arbitrary. It seems to be rooted in notions of fairness.
Yes. And we're all emphasising the critical third point I make, which is that Parliament is then presented with and enacts carefully crafted legislation, each aspect of which, including the ones we've just been discussing, involves, to go back to SC, a paradigmatically legislative choice. Where should the lines be drawn? How should they be drawn? It's clear that, at least in certain respects, again, this isn't an absolute proposition because you know that, for example, 124 does just and equitable and all of that. But in essence, the scheme is a scheme in which Parliament itself is drawing these critical lines. It's a bright line scheme at heart. And the reason for that is set out and explained in Mr Murphy at 79 to 83. We submit good reason, including the usual ones that underpin the need to draw bright lines in a context as complex as this, namely trying to achieve a degree of certainty and clarity. And a bright line rule is normally resorted to, and no doubt was resorted to here, because there are real difficulties with leaving things on a pure case-by-case basis. Now, there may be some elements of the scheme which still involve that decision-making, But if you're looking at it from the position of the framers of the legislation and of Parliament, you're sitting there thinking, well, if I just say to the court, do this on reasonableness grounds, the first thing a court is going to say is, how am I going to determine reasonableness in a context like this, where you've got contracts that say one thing and you're having to alter those? So you've got to some extent, you're driven to bright lines. But that was the choice that Parliament made. And the reference to those lines being drawn is a reference to the lines being drawn by reference to factors that we respectfully submit are entirely coherent. And they're summarised in Mr Murphy's statement at 82 and 83, the factors that underpin the drawing of those lines. So these aren't just bright lines plucked out of nowhere. Very careful thought was given to them. And what Parliament then did was evidently and deliberately made choices across the range of issues by choosing to enact the legislation. As much of this groundwork, as it were, having been done by the presenting department for obvious reasons. And you will have seen that the parliamentary consideration of this, see for example paragraph 54 in Mr Murphy's statement, was preceded by consultation, by responses to consultation under the BDI of the Select Committee, by a whole set of issues being discussed for a period of time against the backdrop of Grenfell. It was high on the national and parliamentary agenda how to fix all of this.
I don't think the consultation specifically dealt with Schedule 8.
It didn't deal with Schedule 8, but it dealt with some of the drawing of the lines which are then reflected in Schedule 8, because they reflect the same kind of values and the same essential drawing of the lines that you see being done in Schedule 8, of course with their own specific judgments about the particular provisions of Schedule 8. But they're not uncommon. They follow a logical theme, the Schedule 8 lines. For the introduction of the legislation and the process, again, you have some, I hope, helpful, at least summary by way of description of the process in Mr Murphy's statement from paragraph 58 and following. And within the section leading to the presentation of the amendments to Parliament, in other words, the Schedule 8 points, see paragraphs 135 to 141 of Mr Murphy for a description of that process. And again, I don't need to get sucked into whether or not particular things were discussed within Parliament, because the effect of the legislation is a matter to be determined on the proper interpretation of it. For this purpose, the premise is that the relevant provisions were retrospective. So that's the third point, that Parliament is making precisely the sort of judgments of virtually the same character as were considered by the Supreme Court in, for example, SC. Where are the yardsticks for the court? How can a court decide that it's appropriate for a provision to have retrospective effect in this way, for a provision that draws a line in that way, that puts this burden on the leaseholders, that burden on the landlords, that expands the causes of action in this way so as to open the door more broadly to consequent actions to recover some of the costs from third parties who might be more at fault. All of those things are legislative choices ultimately, and that is the principal reason, or a key reason, for the breadth of the margin that is afforded by the courts in this sort of challenge. The fourth point is that the measures under challenge here must be seen as part of, and this is really the thrust of my reason, of my answer to my Lord Justice Nugee a minute ago, they must be seen as part of a coherent scheme of legislation, the fundamental elements of the design of which were precisely to set lines of distribution of burden. The measures, in large part, had similar, if not identical, basic underpinnings. A core aim was to provide clear and certain protection, not complete protection, as my Lord Justice Holgate rightly pointed out to me, but clear and certain protection for leaseholders, and to deal with a set of issues associated with the costs in a detailed and, in Parliament's judgment, a fair way. And once that is appreciated, to come to our specific provision, might be thought that it makes rather clearer, or as clear as it could be, that the provisions that you are directly concerned with now are simply part of that overall logic. The aim is to provide that clear and certain protection for leaseholders, and there are good reasons, consistently with that logic, not just for lifting the remediation cost burden off their shoulders to the extent that the legislation does, but also to lift off what might be significant bills associated with those defects. That is what a coherent scheme does. It seeks to treat, in legislative judgment and policy terms, it seeks to treat the underlying logic in a coherent and consistent way. But none of this is absolute. And you've seen there are lots of different ways in which nuanced lines are drawn, but they are ultimately drawn. That leads to the fifth point, which is that the protection of leaseholders from landlords' legal and other professional costs is simply one part of that broader logic. The justification at base is the same as in relation to other species of costs that would otherwise fall on leaseholders. The structure involves seeking to capture, therefore, the wide range of legal and professional costs associated with remediation in broad terms. See paragraphs 86 and 87 of Mr. Murphy's statement in particular. And the reasons for that protection and the inclusion of that specific protection in the scheme is dealt with in detail and in terms in paragraphs 89 to 90 and 147 of Mr. Murphy in particular. Three specific reasons highlighted there: comprehensive and coherent protection, in essence the question, why protect against the costs of, for example, cladding, only for very significant legal and professional costs associated with it to be able to be passed on. Concern about incentives in terms of behaviour if not included in that way, for example, bringing costly proceedings and all of that, and then passing the costs on.
I mean, picking up a point made by, I've forgotten whether it was Mr. Allison or Mr. Bradley. I mean, the incentive point doesn't apply to the retrospectivity question, does it?
Well, my lord, I think it's probably fair to say that it doesn't apply directly to that, but you've got the incentive is created, as it were, by the full nature of those legal costs being protected against. Of course, the action will already have been taken, and so to that extent, my lord is of course right. But I think what Parliament is trying to do is to deal with the incentivising effect of those legal costs and other professional costs being passed over. But I accept, of course, the basic thrust that says, well, if it's already been spent, then you can't incentivise past action. Of course, that must be why it's a matter of logic. And they particularly wanted, this is a point that's made in those paragraphs and also paragraph 91 of the Murphy statement, they also wanted to extend the legal cost protection in a context in which there had been already demonstrated the fact that, unsurprisingly in this sort of area, this was very fertile ground for prolonged, costly and difficult litigation of all kinds. Indeed, that was in large part one of the reasons for wanting to legislate in these ways and for Parliament to be drawing these lines, because you'll recall from Murphy's statement, initially the government had left it to be sorted out voluntarily, as it were, dependent upon the goodwill of all the relevant actors, and that had got nowhere. Indeed, worse than nowhere, because it had led to prolonged issues and difficulties and litigation and infighting, as it were, the effect of which had been to delay critical safety measures being undertaken, because no one could sort out where the costs were going to lie. And as part of that, consideration was given to leaving the protections already in place under the Landlord and Tenant Act in play and doing no more, and that was rejected for reasons that are set out and explored in paragraphs 93 to 95 in particular, Mr Murphy, and then 151 to 155. And that takes one directly to the retrospectivity judgment that has been made. I say the premise for A1P1 arguments is retrospectivity. The reasons for retrospectivity and its necessity, it might be thought, are at least relatively obvious, given the problem that was being addressed by Parliament in this suite of measures. See in particular Mr Murphy's statement at 70 to 72, 2 centuries in which the thing was retrospective, applying to defects created in the 30-year period leading up to commencement, and all the costs associated with that, and applying to relevant defects irrespective of when those costs were incurred or the service charge demands made. It was known that a substantial body of costs had already been incurred, and the idea was to provide protection as against that. And that is of the essence of this legislation, which amongst other things goes back and sorts the historic problem, for example, by opening and extending the limitation periods, but not beyond 30 years. So it's part of a suite of measures that Parliament has decided to put in place in that way. And the particularly, it might be thought this is better addressed under less intrusive measures, but the particular justifications for the retrospectivity of this particular provision are dealt with in 151 and 155 in particular of the Murphy statement. And my learned friend started by having a crack at 150, but as you see from 150, that's dealing with a rather different issue, which is whether or not to exclude paragraph 9 from Schedule 8 altogether. Should it apply only prospectively, alternative option, if that's presented as a less intrusive alternative, is dealt with particularly at 151 to 155. And my submission is that none of those justifications for not doing that, applying it prospectively only, is anything other than rationally connected to the aim and perfectly coherent, particularly when set alongside the basic underpinnings of this legislation, designed as it was to deal with the historic problem of defects created in the 30-year period looking backwards and trying to manage and divide up the distribution of the costs that would be associated with putting that right. So those are the 6 key features of the legislative scheme we submit.
So just to be clear, in terms of the justifications for retrospectivity, is it really paragraphs 154 and 155?
Well, yes, it's particularly those 2. It is.
Yeah.
I don't want to exclude by giving that answer no. 152 and 153 to the extent they're rather more like lead-ins to those paragraphs.
Because 153 recognises you can deal with the 152 problem.
Yes.
So really, it seems to come to 154, 155.
Yeah. But seen in context. Again, I don't want to divorce those paragraphs from the rest of the statement, because this is part of a coherent scheme in which you're effectively treating those legal costs in the same way or in a similar way. You're removing the burdens.
So, just talking around it for a moment, 154, 155, we wanted to remove the burden on leaseholders. It's been explained earlier that this could be a lot of money, so it could be a significant burden on leaseholders, added to which you have a problem about complexity, and you say, well, there's a broader, coherent scheme.
I do. That's essentially what it comes to. So pull the strands together, go back to that Bank Mellat 4-stage analysis, take the first two together, legitimacy of aim and rational connection, the strands are pulled together in this statement from that perspective of legitimate aim and rational connection at 145 to 147. The appellant's case seems to be that the thing would only be rationally connected if it only operated prospectively. And that can't possibly be right. The aims are as described, and you deal with the safety issues by making legislation designed to ensure that they are in fact fixed, and the rest is simply legislative policy choices as to precisely where and how to draw the distribution lines. Prospectivity only, it might be thought, would simply be to introduce an adventitious feature into the equation. The problem is that the defects is with fixing defects that occurred up to 30 years ago, and Parliament has chosen for obvious reasons to ensure that the lines it drew apply to all buildings with those defects. So if you, as it were, cut off prospective, retrospective, and make that the critical feature, then you're simply, as it were, drawing a line based on timing. Less intrusive measures, again, as I indicated when dealing with the principles, that is a question of legislative judgment also. And it might be thought that the prospective retrospective issue falls well within that sphere. Is it appropriate, and if so, in what way, to fashion that protection so that either some or effectively all of the legal and professional costs are lifted off? And again, Parliament could have done that in a whole variety of different ways. Go back to the question I'm going to have to try and grapple with a bit under interpretation. But ultimately, it's a question of judgment for Parliament as to whether or not, if someone's paid, they're covered or not, or they have a protection or not. If they haven't paid, what then? To what extent do you lift that burden off, and so on? Fair balance. There's obviously a clear and extremely compelling public interest in ensuring that the building crisis is effectively fixed. And that does call, if you're looking at a coherent solution in legislative policy terms for that, that does call for a comprehensive scheme. And if you decide you can't just leave that to be sorted out by existing law, you've got to change it. And if you change it, you then got to decide whether you're going to leave it on a case-by-case basis or draw lines. And it might be thought to be pretty obvious why lines were being drawn here. And the rest is judgment. Of course, landlords bear a burden, but so do others, including the taxpayer, including industry. The impact on landlords was specifically considered, see Murphy 102 to 108. Perfectly rational conclusion was reached that as a group they had broader shoulders than the average leaseholder, and that had an effect on where the line should be drawn, and they should do so. The core points that seem to be made on fair balance by my learned friends on behalf of the landlords are firstly that there was no compensation. So you know my answer to that. Unnecessary. This is not a deprivation. It is not an interference of the sort of seriousness that would require a compensation scheme. All the more reason for that conclusion here, given that the distribution in question is essentially between landlords, developers / industry, and the taxpayer. And you know that there has in fact been distribution amongst those three of the cost burden. we know that that distribution has in fact applied in the specific context of the building we're dealing with. We pointed out in paragraph 64 that the developer of this building, Land Securities, has already agreed, pursuant to the developer remediation contract, to manage and fund all life-critical safety work to the building. But the call for compensation sits ill with those judgments about the fair and appropriate distribution of that contribution burden, because the effect of a compensation scheme for landlords would simply be to transfer their share or their part of the burden, or a significant part of it, depending on how it was set up, from them to the taxpayer. Because someone's going to have to fund the compensation scheme, and it will be the taxpayer. So compensation is not appropriate for that reason also. Secondly, it said that the landlords bear the entire burden of the retrospective impact. Well, the matter needs to be looked at in the round, I submit. The retrospection or the retrospective element is but one element in that. And the distribution is in the manner indicated. You have to view that package of measures as a whole. In any event, what are called the residual costs are apportioned under the legislative scheme. I think it's the point my Lord Justice Holgate was putting to me earlier on, by reference to likely culpability and the ability to contribute. Some costs may still be recovered from non-qualifying leaseholders or those within the cap, 4 and 5 of Schedule 8. There's an apportionment of liability within buildings with multiple landlords, depending upon their level of interest within the building. We dealt with that in our skeleton 21 and 25. And there's also the ability to recover significant funds for landlords through government funding, developer funding, and claims against third parties, where Parliament has chosen to make causes of action easier to pursue, so as to enable a more direct targeting, but in a way that involves making those claims, allowing a further spread, as it were. And fundamentally, and at bottom, as I've already indicated, the government assessment was that it was appropriate for landlords to bear that burden, and they could do so. 102 to 106 of Mr Murphy's statement sets that out. The assessment was that it would only be a small number of cases where the landlords might not be able to meet their liabilities. And it appears that this particular landlord was able to do so and would be able to do so. It collected the whole freehold investments comprising, we're told by Mr Anderson's statement, of 200,000 houses and flats located across England and Wales. The third element of the challenge to fair balance is that there was no individualised consideration. Well, again, you know my answer to that. It's a matter for Parliament to judge whether it wants to draw the lines, and if so, how. Bright lines are important to ensure effective protection, effective rectification, and the sort of clarity and certainty that was considered by the government and Parliament to be essential. So that's what we say about justification. Section 3 of the Human Rights Act, if you're against me, take it quickly, because it's a short point. We know from case law way back when, just after the Human Rights Act was passed, Poplar Housing, I think it was Lord Wolfe in Poplar Housing, made it clear that you don't get into Section 3 territory just because someone mutters human rights. You get into Section 3 territory only if, on a natural and ordinary interpretation of the provision, there would be incompatibility. And this is a challenge, as you will recall, that although brought by an individual landlord, is in effect a challenge to the legislative scheme. It's one of those Christian Institute type challenges. It may not matter much, but it's a challenge to the legislation. The Poplar Housing says you only get there if, on a natural interpretation, there would be incompatibility. Section 3, if you do reach that point, then allows for the art of the, quote, possible. That's the key word in the Human Rights Act. And we know from the case law, including Guyton and Mendoza and a whole series of other cases, that ultimately Section 3 and the art of the possible has two key elements built into it. The first of them is an interpretive element. Are you pushing the boundaries too far of interpretation? There's no citation of some cases in which even an implication of words has been within the art of the possible. It all depends on the legislative scheme. And indeed, sometimes applying a purposive interpretation, even on ordinary principles of interpretation, you can imply words. One thinks of cases like Quinta Valley, the cloning case, where the concept of embryo in the Act had been defined to cover embryos created by the mixture of sperm and eggs, and cloning involved none of the above, but nevertheless plainly needed to be regulated, so they implied words. So you can imply words in certain circumstances, but it's pretty rare, and you're on the boundaries of the reservation in interpretive terms if you go anywhere near that. But the second and critical feature built within the art of the possible under Section 3 is a constitutional one. And it's that feature that perhaps creates the distinction between the Section 3 approach under the HRA on the one hand and the leasing approach that my Lord Justice Nugee asked my learned friend about. They are similar in terms of what they allow you to do and their strong interpretive tools. But the difference with Section 3 and the Human Rights Act is that it requires you to consider and to address the issue of what is possible, having regard to your place and Parliament's place in the constitutional setup. And that goes to the critical distinction between judicial interpretation on the one hand and judicial legislation on the other. So all the matters that bear on that distinction, including, for example, whether you are well placed in a complex scheme to make the kind of balancing social judgments that would be required if you're going to pull one bit of the tapestry, the social and legislative choice tapestry. Are you well placed to make the judgments as to how you should do that? They are critical to the Section 3 analysis because of that constitutional aspect of Section 3. And it's those ideas that are incorporated also in the description, the headline description of things being against the grain of the legislation. Does it cut across those balances? And that is, both of those features are important and potentially difficult in the present situation. Because if you, for example, alter one part of the scheme, you alter, I don't know, paragraph 9, what then does that do to the inherent logic in the scheme? What does that do to the careful balancing that is inherent in all of the lines that Parliament has drawn as a coherent legislative scheme? And it's very, very difficult, I submit, for the court to be making those judgments.
If we got that far, would it be that hard here? I mean, at least on what we're being asked to do in this case, it's just a matter of whether Schedule 8 applies retrospectively. Does that really subvert the overall scheme, run against the grain of the legislation?
Well, my submission is that it does do, because you are, as it were, picking at the fabric of the legislation if you do it in that way. I mean, it may in itself be viewed in isolation, as it were, a relatively easy matter to say, well, we're prospectively or retrospectively, where's the difference, as it were. But once one understands the way in which the Act has been set up, once one understands the policy drivers for the choices that are made, once one understands the basic underpinning of the logic of this legislative scheme, it becomes much more problematic, I submit. Of course you can say, well, there's only legal costs and professional costs, and that's a small part of the bill, and they've cut it in a slightly different way in 124 because just and equitable has been allowed in, and all of that, of course, but those ultimately, it might be thought, are legislative judgments. So the more complex a scheme, the more difficult it becomes, I respectfully submit, when you've got echoes across that scheme. That's how we push it anyway, on Section 3. Well, finally, interpretation. promised I'd take you to Lord Justice Singh's judgment in DK at the risk of reopening unwelcome wounds. It's tab 60, if you would. And the paragraphs I really want for present purposes, the context doesn't much matter. By all means, have a look at the head note for interest if you will, but it was a question of interpreting some regulations to do with asylum seekers and social security. But the paragraphs I want are on page 2107, paragraphs 43 and 44. And you'll see that what happened was that the Secretary of State had tried to introduce, and had been allowed ultimately, was allowed ultimately to introduce an additional witness statement from an official of the department there for the DWP. Can I just invite you to read 43 and 44? They're pretty simple.
I'll do that.
You can't do my subjective intention was, the department's intention was to do this, that and the other, but sometimes it may be helpful. So it's a more limited role in this interpretation context than the importance and relevance of such a statement when justifying compatibility. But nevertheless, it is possible to put in statements and sometimes useful for the court to be assisted by a statement on behalf of the government which sets out the legislative background and history. It helps the court to ascertain the context and purpose of the legislation and then drawing the distinction. That's not the same thing as a subjective what it means. So that was the only authority I wanted to draw to your attention on that. I was on interpretation. I'm going to tread very gingerly, not least because of the thoroughgoing expertise of others in this course on the underlying context and legislative schemes that may be in play. I wanted to make only 4 short points, if I may, on interpretation, and they all essentially go to the same end, which is our submission that the Upper Tribunal, in their careful analysis, were correct. The first point is that the plain words of both 9.1 and 10.2 indicate that no service charge is payable in respect of what the Upper Tribunal called qualifying services, trying to simplify things. That phraseology was designed by us at paragraph 124 of its judgment. And the key question that they identify, which we respectfully submit is the key question, is how those provisions were intended to work, and in particular paragraph 9.1 was intended to work in chronological terms. That again was 1, 2, 4 of the Upper Tribunal judgment. And the answer that they gave to that question on the plain wording, as it were, was that from commencement, no service charge is payable in respect of qualifying services. There was no temporal limitation in paragraph 9. Paragraph 9 is not framed by reference to incurring the costs of the relevant services. It simply asks, as the Tribunal pointed out at 151, it simply asks if the services, quote, relate to the liability of any person incurred as a result of a relevant defect. And of course, it won't escape the court that if the appellant is right, a service charge is payable in respect of legal and professional services, but just in relation to those billed or incurred before commencement. That's the first point. Second point is that paragraph 10 does not alter paragraph 9. It is to be read with paragraph 9 9, it is, as the tribunal put it, the Upper Tribunal put it, at paragraph 153, the mechanism by which the result is achieved that no service charge is payable. It doesn't limit paragraph 9. There's nothing in paragraph 10 to limit the concept of costs incurred or to be incurred to cover those from commencement, as my Lord Justice Newey noted. That's the point being made by the Upper Tribunal at 152. Thirdly, purposive considerations provide very powerful support, we submit, for the conclusion reached by the Upper Tribunal. See, for that purpose, I want to show you actually one authority and then go to the Upper Tribunal judgment briefly in relation to that. The authority that we've given you in the supplemental bundle is one of two, which are the, perhaps one of three if you take Rossendale into account, which are the latest words from the Supreme Court about the approach to interpretation of PACAR. It's at tab 4 of our little supplementary bundle, and the paragraphs I wanted for that purpose are paragraphs 40, page 180 in the bundle, paragraph 40, really through to the end of 41. Again, can I invite you to read that? Just to remind yourself, they cite in particular Quintavalli, and which was the cloning case I was describing earlier, and Rossendale.
I'll do that.
Pretty well-known ideas, but I really go there because there's quite a pithy sentence right at the end of 41 that it might be thought really captures the approach. The purpose and scheme of an Act of Parliament provide the basic frame of orientation for the use of the language employed in it. That's the connection, as it were, between, and then Lord Justice Nugee and I have discussed this idea in the past as well, but it's that idea that links purpose and wording all as part of the composite whole. Can I go from there to the way in which the Upper Tribunal dealt with purposive considerations? That's in tab 30. No, that's all right. Sorry. Reported, I know my Lord was using the reported version. And that, I think, is in the core authorities bundle at tab.
Don't worry for my purposes, I've got it loose.
You've got it loose.
I'm reading it in the core bundle. Paragraph.
Paragraph numbers 155 to 158. Again, my lords will have seen these blocks already, so they can take it pretty shortly. So in essence, Parliament was seeking, as indicated, to provide for certain things, that's the word in paragraph 10.2, to provide that certain things are not payable, so as to ensure leaseholder protection as part of cost distribution. You must be right about that. And then Schedule 8 then removes the things identified, which are essentially categories of cost that would otherwise feed through into the service charge to the detriment of leaseholders. And Parliament was trying to fix that and to fix it in a clear and certain way. And I respectfully submit that 157 of the Upper Tribunal's reasoning is unanswerable and very, very important. So that's their reliance on purposive matters, and we respectfully submit correctly so. The fourth point is the obvious one, which is that the paragraphs in Schedule 8 have got to be read as part of the composite scheme of sections dealing with similar issues that exist within the legislation. And I take but two of those as examples. The first is that if the appellant is right their construction would apply to paragraphs 2 to 4 and 8 as well. And that's very difficult indeed to square with the basic and fundamental purpose of the BSA. Paragraph 8 prevents leaseholders from paying for cladding remediation. If incurred or to be incurred means that costs incurred before the 28th of June 22 are not caught, then leaseholders would have to pay for cladding remediation which took place in earlier periods at a potentially ruinous cost. That cuts across, very fundamentally cuts across, a basic policy intent of the Act. Note also 124, section 1242, Core Authorities, page 30. That uses, you will have noted, I'm sure, the same phrase, costs incurred or to be incurred, which the Secretary of State says has retrospective meaning. Submissions on that are going to be made in triathlon.
I think the word payable doesn't crop up in section 124. It's just costs incurred
or to be incurred,
I believe.
It is. In other words, you've still got that same basic conception in there. As you'll recall, the first tier tribunal concluded that those work on their own without the payable thing, whereas they put it in paragraph 73 of the FTT judgment in triathlon, clear and explicit, and there was an absence of temporal limitation or transitional provision which was telling, was the way they put it, paragraph 73. I was in the vexed words in 10.2b. If I can make a short stab at that, as it were, and leave that to others with greater brains and experience than mine. The position that we take is that if the leaseholder has paid, then it can't simply be clawed back under 10.2b. There is the possibility of using 124, but that is subject to the just and equitable test, as you know, and that would then mean that the tribunals would have to make a judgment about whether or not it was just and equitable to go back so far. But we say that 10.2b does not enable one simply to go back and, as it were, cut across that and simply reclaim if you've paid already.
Why doesn't it? Either in terms of a straight cash payment or in terms of working through the service charge accounting so that for the future less is payable?
Well, my lord, because that would cut across 124 we submit, so it wouldn't be coherent within the scheme of legislation. The wording used is payable anyway in 9.1, and the references to repayment in 10.2b we respectfully submit are designed to cover a payment after commencement that has been made, for example, by mistake. And that, I know we've got a great big debate about the extent to which you can rely on explanatory notes, but that seems to be the idea that is put out in the explanatory notes at 1765, paragraph 1765 of the explanatory notes. Sorry, no.
Well, it's one way to approach the Schedule A paragraphs, is obviously to observe initially it refers to payable.
Yeah.
But the draftsman has chosen not to make the mechanism or the operation of the scheme depend solely upon that word payable. So it looks as if it's just shorthand for what is spelt out in paragraph 10. And when you get to paragraph 10, so in other words, what we see in paragraph 10 is not having to be repeated endlessly in each of the preceding paragraphs. But when you get to paragraph 10, payable drops out of the picture because it's defined in terms of what you see in
A and B.
In A. So it seems like a word-saving provision. In which case it would align with 124, and
but it wouldn't alter that position.
It
wouldn't enable you to go under 10.2b to achieve an effect that was contrary to 124.
Well, following on from my Lord's question, if repayment means what it says, does what it appears to say on the tin, how is that necessarily incompatible with 124?
Well, it just might, I think the concern is that it might open up, treated too broadly, it might open up a situation in which you didn't have to bother with 124 and just an equitable test, because you simply go under repayment.
You wouldn't have to bother if you were a leaseholder falling within the protection provisions, which for the most part applies to those who live in their properties or have only, I think it's 2 homes in the UK. All the other landlords, save where you're dealing, leaseholders, sorry, save where you're dealing with paragraph 2, where the landlord is responsible.
Might be, yes. Well, I see that.
I mean, you would expect it to join up.
You would.
At some point.
Yeah.
Can we just talk through it for a moment? I don't know whether to take the extreme case of the fire doors in 2007 or the remediation work in 2018. Let's take remediation work in 2018. So 10.2a, no costs incurred in respect of that remediation work are to be regarded as relevant costs. And on your case, that means you strike out from the service charge accounts the costs incurred on remediation in 2018. So what's the implication for B? Any amount payable is limited accordingly, and any necessary adjustment must be made by repayment, reduction of subsequent charges or otherwise. So you've struck out the cost incurred on remediation. What's the implication for B?
It must be limited accordingly.
And so how does that work? Only for the future? So when you get your next service charge demand,
well, my understanding, I mean, I'm not sure in truth that the draftsman has grappled with those sorts of issues. But my understanding is that the reason for 10.2 is, as my Lord says, to be a word-saving thing. And the critical feature of this structure, 9 and 10 together to bear in mind, is that the basic idea that no service charge is payable.
yes, I see.
And that's how we put it. And so these are, as it were, just working through that basic idea rather than seeking to alter it. I think it's that leads to the department's position that if you have in fact paid, albeit you're entitled to try and have a go under 124, this isn't seeking to do something rather more fundamental.
Well, as was pointed out also this morning, there's subparagraph Roman 2. This is prohibiting what can be done. So no costs are to be regarded as relevant costs. So that engages the provisions in the 1985 Act. And then we're told it's not to be met from a reserve fund. And then B says, if any amount is being payable under the lease, sorry, any amount payable under the lease, which is taking one back, I think, to the 1985 Act, or met from a relevant reserve fund, it's limited accordingly. So the repayment, for example, would require repayment into the reserve fund. This is all machinery, counting machinery, rather adjectival law, perhaps, rather than substantive law.
Oh, yes.
And you're going to get these questions, whether these provisions are entirely prospective, because money might have been taken out of a reserve fund if these are prospective provisions only, but there's provision for repayment. Otherwise, it's toothless.
Oh, yes. I'm not sure I can take it much further.
Can I try one more go? Go back to paragraph 9.1.
Yep.
No service charge is paid. That comes into force on 28th of June,
Yeah.
2022, does it affect a service charge which was properly charged, demanded and paid before the 28th of June, 2022?
My lord, we say no in answer to that question.
Well, that's what I thought your answer was, but that seems to me to be a different answer from the answer. Because when I asked Mr. Loveday, he said yes.
Well, that's a matter for him.
Yes. Yes, but I just wanted to be sure what your position is.
Paid.
That once it's paid, this only kicks in on the 28th of June.
Yes.
And my understanding, when you say it's retrospective, Mr. Murphy says it was intended to be retrospective because that's what you need to protect leaseholders. What you mean is it only applies to service charges which have not been paid before the 28th of June, but you can't be required to pay after the 28th of June, whether the costs were incurred before that date, or the liability incurred, or the services rendered, and so on. Have I understood your position correctly? Yes. So that answers that. I asked you to pay a service charge for replacing the fire doors in 2005, because this legislation doesn't affect that at all on your view, whereas on Mr. Loveday's view, he accepts. He says he took it on the chin.
But that also is what underpins the reasoning of the Upper Tribunal, as I understand it.
Well, that's rather what I think.
Because they concluded, as you will recall, that it wasn't retrospective in the sense that would engage the presumption.
But that, exactly.
I can have an argument about that, but their basic conception of it was that it was prospective, but with retrospective effects in a broad sense, because this was setting out the mechanics of how
if we spell it out, I think your interpretation, and by my reading the Upper Tribunal's interpretation, is no service charge is after the 28th of June payable under a qualifying lease in respect of legal or other professional services, etc., incurred, whether incurred before or after the 28th of June.
That's exactly the sense of it. Yes. That's how we put it. And if we're different from Mr. Loveday, well, so be it.
Well, it is different from Mr. Loveday, and it's also, of course, very different from Mr. Allison.
It is.
Mr. Allison says, no service charge is payable in respect of legal or other professional services rendered after the 28th of June.
Yeah.
And Mr. Loveday, as I understand it, says no service charge is or ever was payable.
Yeah. Well, Mr. Allison runs the two cases that you see being separate.
He does, but his primary cases.
Yes. But his alternative case was the one about service charge. If the service charge comes after all, is
well, I think it was the service charge demanded. Now, that's not quite the same as whether it was paid.
No, it's not. It isn't. But my lord, you have exactly how we put it. And of course, that is consistent with what was said to Parliament in Hansard, what that's worth.
Yes. And it's also consistent, I think, with what Mr. Murphy says the policy intention.
Yes. Well, no doubt.
I didn't see anything in there about reopening the last 30 years of accounts.
No. Oh, well, can I just finish?
So on that basis,
yes.
Taking that approach, does it mean that when we look at Schedule 8, the word payable does have a substantive effect? It's not just down to the words incurred or to be incurred. Or does it colour what is?
Well, it may.
Why is payable in there?
Because it is doing extra work.
Yeah, exactly. Which is not present, then is not present in 124.
Yeah. It isn't, so there may be some significance in that.
I think we need to understand that.
Yeah.
When we get to the other appeal.
I see that. Oh, sorry. Can I finish on explanatory notes? I don't want to reopen. But again, it may be a point of some importance. You will have seen recently from the Packard case I took you to that Lord Sales had a bit of a crack at that as well.
Actually, I didn't notice that.
It was the paragraph. I was deliberately showing you the paragraph immediately preceding having a crack at that. But he does it for a slightly different way. He uses the form of words you've seen before. I think it was 42 in Packard.
I see, yes.
Do you see? He's using that familiar form of words, legitimate to refer to explanatory notes which accompany the bill in its passage through Parliament, which under current practice are reproduced.
Sorry, that's paragraph?
paragraph 42 on page 181.
Sorry.
No, so, I'll just break it down into bits. One, if explanatory notes accompany the bill through Parliament and are therefore taken to have been considered by Parliament, they accompany the bill through its passage, then they are legitimate aids to interpretation. Right? The thrust of both Lord Sales in Packard and earlier Lord Hodge in Earl, which was the second of the ones reinventing the interpretation wheel, both of whom deal with explanatory notes. The thrust of both of them is to acknowledge that they are legitimate aids of interpretation, but they're secondary.
Yes.
That's the idea that they're getting over. So they're not actually considering the point that we're dealing with. They just assume that the explanatory notes have that greater force, and then they're still secondary. That's point one. Point two is the Mr Justice then was Lloyd Jones' point, which says if you've got explanatory notes that post-date the relevant legislative provisions, as our ones do in relevant parts, then they do not have that status. That does not mean that they are irrelevant, because as Lord Jones recognised, they can be relevant, but the question then is a different one, which is one of weight when considering the legislation. And they have such weight as their content will bear, is perhaps the principle. So if you're dealing with the position as Lord Lloyd Jones was dealing with it in the case that you were taking to Wright, I think it was, you were dealing there with Home Office guidance about the legislation. Well, they've got some weight, and he said, you know, a bit like a textbook or a statement by an author or something. But they bear the weight that can be accorded to them. So they're not irrelevant, they're not inadmissible, they are useful for the use that they have, recognising that Parliament did not take them into account. But they can still bear on interpretation depending upon what, it depends on what weight you give them. And so there may well be a difference between a kind of ex cathedra statement of conclusion in explanatory notes, it is retrospective full stop without anything else, as compared to a really quite detailed exposition of a set of provisions or a provision. And here, at least, one can legitimately say that the relevant explanatory note, albeit ex post facto, did descend in a complex scheme of legislation into some considerable detail on some aspects. But no one is submitting, I think, to you that as ex post facto explanatory notes, they bear the sort of interpretive aid weight that explanatory notes that accompany the thing through Parliament would bear. But they're not irrelevant, they're not inadmissible, it's just a question of judgment as to how much they assist you. That's how we put it on explanatory notes. Yep. Well, those are my submissions, unless I can help further.
No, I didn't detect any more questions, so thank you very much. Who's going next, Mr. Vernon?
I'm first up, my lord. On A1P1, I'll start with deprivation/control, which, as you will have seen from how Sir James puts his case, really drives the framework for analysis. So it's quite important to look at how and why Strasbourg and the domestic courts, I say, conceptualise the concept of possessions. And I already took you through yesterday the Strasbourg cases on which Sir James relies, so I'm not going to go through those again. The key point is, as your lordships will recall, in none of those cases was the government, the relevant government, trying to regulate matters that were entirely in the past. Rather, the government was trying to regulate what future use could be made of the property in question. And it was for that reason that conceptually they were controls on the property, because they were controls about what future use could be made of that land. And the reason why, as we saw when we went through the cases, why the court was looking at it through that lens, why they were asking the question, is this a control or is that a deprivation, is because that is how the applicants had put the case to them. Because they were saying, as you saw in all of those cases, the facts, because of that lens, the facts obviously were extreme and they were different to this case, I accept that. But what they were saying is, because of those extreme facts, of the extreme effects of that prospective control, it's actually a deprivation of the property itself. And that's the proposition the court was rejecting. Now, it doesn't go as far as Sir James needs it to go, because in none of those cases did the government say, for example, here is the rent cap for next year, but also, this is our case, what's missing from that case, but here in this case, but also, if you have any outstanding rent demands from the previous year that are still payable, we'll rip those up. That's the difference. And in that case, I say there would have been a deprivation of the sums due in respect of past rent. And that would not be, conceptually, looking at how the court dealt with it, a control on the land, precisely because it's not prospective.
Can I just try one point on you? So suppose you are indeed a landlord and there's a provision for a tenant to pay rent. And suppose that on the face of it, so much has become due by way of rent, and the government says you can't have all of that, you can have part of it. Is that a deprivation?
It would be, well, if one said, so, analysing it the way I analyse it, the possession would be the entitlement to that sum of money that was outstanding. It would not be a deprivation of the whole sum. So it wouldn't be. I accept that. It would be a control on that. And the question would be, then, well, you look at Mott and you say, well, in substance, what is it? Is it on that spectrum? Is it actually a deprivation or is it actually a control? And you saw in the case law, when you say, well, actually, the rent that you can have is 0.5% or whatever it was, there will come a point where it actually will be a de facto deprivation. But I accept then, no, it would be a control of that right.
So can I, at the risk of atomising as not favoured by Sir James, you start with the ownership of the property. Let's narrow it down. You have a contractual right to call for service charges. Let's narrow it down further. You have a contractual right to call for service charges of X in respect of a particular year, leaving aside the complications of mechanism. Part of that X will presumably be attributable to your legal costs, but not all of it will, probably. So why is that different from, well, you can have some of your rent, but not all of it?
Because again, the nature of the possession, that again, it's the way that one conceptualises it, is that the possession in question is the debt, the bit that's accrued already. It's not a future control.
No, I follow that, but suppose that you've put in a service charge demand, some of which is attributable to what we're arguing about, but some of which is not. Then
I see. I accept that would be, if one conceptualises it that way, then again, that would be a control. And then one would be on that spectrum, and you would analyse it, and you would say, well, are we in the territory where really what we're dealing with is a deprivation?
Yes.
And I say, because of the effect of these provisions, you are in that territory. So no, but I accept conceptually that is exactly how you would do it. So at this stage of the analysis, we're looking at what is the nature of the possession, what is the possession, and the next stage is, well, what's the impact of the measure on that possession? So I accept that. And that's why when one follows the various cases that Sir James took you through, you see how the analysis would be different. For example, in the tobacco case, well, as my Lord Justice Newey pointed out, that was a case where the controls on the trademarks were operating prospectively. And again, to make the change to the facts that I just drew in that case, that said not only can you not put your trademark on the front of the packages of cigarettes, but any royalties in respect of past use of those trademarks, rip them up, then would be in a different territory. But at one point, and this is a separate point, because at one point what Sir James said is that actually the tobacco case is authority for his proposition that one doesn't look to atomise the nature of the right, and really said that the court was sort of pouring some cold water over the attempt there to say, well, this is all about trademarks rather than the business. That's simply incorrect. That's not how the court approached it in that case. The court accepted that the relevant possession was the trademark. And the reason why it amounted to a control, not a deprivation, was precisely because that trademark still had some economic value. So true it was, the court said, that you couldn't, it had a much reduced value because you couldn't put it on the front of your packets of tobacco and sell it in convenience stores. But the evidence was you could still do various things with it, including market it for things that weren't tobacco. So that's paragraph 106, which I think was the paragraph after the passages that Sir James took you to. So I'm not going to ask you to turn that up. But the short point is that none of the cases, domestic or Strasbourg, support the analytical framework, the strict analytical framework Sir James was suggesting, that just because the right in question is related to or arises from a piece of property, real property here, any interference with that right is as a question of analysis to be treated as a control of the property from which it derives. And the short answer to the question, well, where are the cases where the court has grappled with the case of retrospectivity, is actually none of these cases are ones where the government has gone that far. So we are in relatively novel territory here because the government has gone further than that which the governments in any of those cases had gone. So Sir James says, actually, when you look at the features of all of those cases about the extent of the prospective controls, they're of a different nature to what we have here. That's absolutely correct, and that's why the analysis was different about what was necessary by way of justification. But the particular vice that we're concerned with, the retrospective taking of sums that had accrued, just wasn't present there. So one approaches it in my submission as at a level of principle, and that is, what is the possession in question here, those accrued rights, and one then follows from there. That's all I wanted to say about the nature of the possession and what one does with it, other than to say, again, and I made this point yesterday, and I think Sir James accepts it now, that even if you're in the control territory, you take as Mott says you must, a realistic view of what's actually going on here. One doesn't get trapped by particular definitional niceties. One's looking at what is it that you are really, what is the nature of the interference that you are in fact suffering, and what is the justification offered for that. And that is the analysis you're involved in. Now, that brings us to the next theme in the Secretary of State submissions, which was that despite all of the Strasbourg authority I took you yesterday and the way that was analysed in the Welsh asbestos cases, actually somehow by a sidewind in a series of cases dealing with a completely different issue about discrimination and within the ambit of convention rights, the court had domestically changed the approach that was to be taken in A1P1 cases. And that is wrong. So my learned friend's starting point was that where I went wrong and where I'd invited the court to go wrong was to take the analysis of Lord Mance in the Welsh asbestos case. Now, the reason why I took your lordships to the Strasbourg case law first is that what one saw then was that Lord Mance was starting with the well-known Bank Mallat test, the four-stage test. And then he said, well, the Strasbourg case law in the A1P1 context has tweaked that somewhat, and then went on to explain how. Now, that was specifically about A1P1, and you saw it dealt with James, it dealt with the Czech case, the Polish case, all of the cases I took your lordships to. And then it reached its conclusion. Now, what Sir James says is that actually in those cases that he took you to, that I'm afraid we are going to need to go back to, the Supreme Court has said actually that's a heresy, even in the A1P1 context. That actually now there is an across-the-board test when one is coming to analyse justification in convention cases, including in A1P1, and that is that you approach all stages of the test as though the test is the government's justification manifestly without reasonable foundation. And let me say that would be an extremely radical conclusion if it were one the court was to reach. And the Supreme Court, in all of the cases Sir James has referred you to, didn't go that far, nor did the Court of Appeal in the JCWI case that Sir James mentioned, which was also an Article 14 case. So what I'm afraid I am going to have to do with some care now is take you through what the Supreme Court has said. Because I accept, absolutely no, you won't hear anything other from me, that the test in Article 14 discrimination cases, when it comes to justification, is now the manifestly without reasonable foundation test. That is absolutely clear. Although, as we'll come to see, Lord Reid in the Supreme Court in SC has walked back from some of the more extreme implications of that. But to just explain at the outset why Article 14 and discrimination is different to A1P1, and not, as Sir James asserted, a fortiori, is that discrimination in convention cases arises, your lordship will be aware, when the government is acting within the ambit of convention rights. So normally, in order to found a substantive breach of a convention right, you have to actually engage that right, and the government has to have breached it. Article 14 is different. If you are acting within the ambit, and the last word on this from the Supreme Court is that acting within the ambit means doing something with more than a tenuous connection to a convention right, then the government can't discriminate on the grounds of, there's a list of statuses, or any other status. And what Lord Reid says in SC, we'll see in a minute, is that actually you'd have to be a pretty unadventurous lawyer not to be able to cook up an Article 14 claim about pretty much anything. And that is why when you're operating in that context, the court takes the view, as we'll see, that it would be a recipe for legislative deadlock if you didn't have a considerable margin of appreciation for the government in those areas. And the argument that they had in some of these cases, well, what about if the discrimination is about particular suspect categories? And the court said, well, actually, even then, manifestly without reasonable foundation, will still have a place in the argument, but it won't be applied as strictly. So it is the case law that Sir James took you to was case law that was dealing with that particular issue that is qualitatively different. And that's by way of introduction. Let me now take you to what the court has said, and I'll do it first by reference to the DA decision, which is in, you have the hand-up bundle from this morning from the Secretary of State. That is the DA decision. So this is Lord Wilson recognising that there was the wrong term. Can I ask the court please to turn to paragraph 55, which is on page 20. And you'll see the issue there. The court has been proceeding down two different paths in its search for the proper test by which to assess the justification under Article 14 for an economic measure introduced by the democratically empowered arms of the state. In retrospect, this duality has been unhelpful. I regret having contributed to it. So that's the issue. Article 14. These cases are all about legislative decisions about public benefits and eligibility for welfare benefits, and the distinctions that are drawn there. One turns over the page, you get 59. You see the conclusions, what Sir James took you to, except now that the weight of authority in our court mandates inquiry into the justification of the adverse effects of rules for entitlement to welfare benefits is by reference to whether they're manifestly without reasonable foundation. Now, I accept that it is not limited to welfare benefits. That much is clear. It is an Article 14 specific rule when you are dealing with areas analogous to welfare benefits, where there are judgments that are being made in this very broad socio-economic policy area. But again, it's Article 14, precisely because of its breadth. Then one goes over the page, and Sir James took you to this, paragraph 61. And this is where the wrong turn started, and it's because Lord Wilson acknowledges he somewhat flippantly, one might say, or at least without proper analysis, cited the medical costs for asbestos diseases decision as authority governing the Article 14 situation. And of course it isn't, we saw it, specifically about A1P1. Cites the A1P1 authorities. It identifies, I mean, Sir James mentioned the James and United Kingdom case. Of course, that was an A1P1 case. But as Lord Mance explains, in the asbestos case, things have moved on in Strasbourg, and that was what he was dealing with. And then 61...
Yeah, I mean, Lord Wilson does acknowledge it was dealing with A1P1 later on in that paragraph.
He absolutely does. This is what he's saying. He's acknowledged that it was a wrong turn. So this is what he's saying here. He's explaining that he was wrong to say that that case was relevant or was authority for the proposition that in an Article 14 case, you only apply the MWRF test to the earlier stages and not the latter stage. So he absolutely is acknowledging that. What he's not saying is that actually it was a wrong statement of the law about A1P1. Obviously that wasn't what this case was about, and as we'll come on and see, it isn't what any of the subsequent cases are about either. Because what he then moves on to do, I don't want to dwell too long on this because the latest word on this is the Supreme Court in SC, but we'll get to it. As he then goes on to address what the position is in this Article 14 context. And as I say, that is a very different context to the A1P1 context. So that's that decision. It's not saying the asbestos case is wrong about the approach to take under A1P1. And if that were the submission, it would be wrong, because for the reasons I went through yesterday, and I don't think Sir James quibbled with, certainly didn't address it, Strasbourg authorities on A1P1 are entirely clear and constant, to use the important phraseology, about what is required, and that is what Lord Mance was addressing. Anyway, things have moved on because we now have the SC case. And this is where it is rather important to see.
And that's where we should go.
That is exactly where we should go. So it's at tab 61 of the Hippersley Authorities bundle. Can I ask your lordships please to pick it up at page 2126. Because this sets out the scope. So as Sir James rightly points out, you have a very impressive bench assembled to deal with what were knotty issues. So it's not going to be surprising that what they are saying is clear about what they wanted to say and the extent of it. So paragraph 1, you see that the subject matter is it's about entitlement to welfare benefits, specifically child tax credit. And then at paragraph 3, you see the relevant complaint. Paragraph 2, you see the structure of the judgment. And then at subparagraph 1, again, you see the subject matter. Subparagraph 3, you see the relevant complaint, because it said after an introductory discussion of Article 14, that's the discrimination right, then consider the complaint that's being made, which is Article 14 taken together with Article 8 and Article 1 of Protocol 1. So what's being said is the complaint is the government is acting within the ambit of Article 8 or Article 1 of Protocol 1, because it's about child tax credit, which is not more than tangentially related to family life, and A1P1, because it's more than tangentially related to property rights. Discrimination. Then there's accepts on the evidence that there's a presumption of discrimination on the grounds of gender, and therefore it's for the government to justify. So that's the issue. Within this very broad area where the government is acting within the ambit of convention rights, there's a prima facie differential treatment, and it's for the government to justify. And then we come over the page to subparagraph 7, and you see that what the court's turning to do in the bits that we're going to come to is addressing how the court should deal with that question. In relation to the question of whether the measure is, insofar as it raises a presumption of discrimination on the ground of gender, has an objective and reasonable justification. And then there's a series of sub-questions about how one answers that question. The relevant one, subparagraph Roman 2, is whether the approach to proportionality under Article 14, as set out by this court in Humphrey and followed in several later cases, is the MWRF test, and whether that should continue to be followed. And that question is considered at paragraphs 97 to 162 below. So again, those passages, which we'll come to, and the other ones James took you to, are dealing with that question, not A1P1. And then the relevant discussion starts on page 2152. Paragraph 97. You see again, this is a restatement of what we've just seen. So the court's again being very clear about what it's dealing with. Article 14, not A1P1. Then there is a detailed survey of the Strasbourg case law in respect of discrimination cases. Unsurprising. If you recall in the Welsh asbestos case, you had the survey of the A1P1 cases. That's what Lord Mance was dealing with. This is dealing with a different question. So it surveys all of the discrimination cases, does that at quite some length, follow that through. The court's conclusion on those after several pages of close analysis is at paragraph 115 on page 2157. And then you see what the summary that's being given there is, again, about discrimination. Sorry, this is page 2157.
Thank you.
Paragraph 115. So you have a summary of the Strasbourg Court's case law in respect of how you approach Article 14 and what's required by way of justification there. And then, if there's any doubt about that, you turn the page and you see paragraph 118. It's about the margin of appreciation in assessing whether and to what extent differences in otherwise similar situations justify a difference of treatment, and that's stating what the Strasbourg Court has said about that. And then what the court does is goes and looks at how that aspect, Article 14, has been applied in cases concerning discrimination in relation to welfare benefits. So that particular context, factual context they're dealing with there. And then we turn to page 2162, and you see there's a summary of the cases to that point, paragraph 129. So you've got a summary of the approach that the Strasbourg Court has taken in this context in relation to Article 14. And the reason why they're saying up to this point is, of course, the argument that's being put to them is actually there are some subsequent Strasbourg cases that have changed the position when it comes to particular suspect categories. And then the court goes on to deal with those points. You see that starting at the foot of page 2162. And if we turn the page to turn over the page to paragraph 132, you'll see what was an issue in that case. Discrimination. So again, that's what it's dealing with. Article 14, discrimination. Turn forward to page 2166, paragraph 142. You see the summary of the position that's being set out there. But again, that's a summary of the Strasbourg position about Article 14. Then you see that there is a sort of a cap at the end where it says that this approach, so the approach that I've just spent a long time summarising, is not confined to cases concerning Article 14, but can be seen in other contexts where the state generally enjoys a wide margin of appreciation, where other factors might indicate a narrower margin of appreciation. Then it gives some examples of that. So what it's saying is, here's the position in respect of Article 14, and then the Strasbourg Court sometimes does that in other contexts. Importantly, one of the contexts where the Strasbourg Court does not do this is A1P1. And that's what we've seen in the Strasbourg cases that I took you to. And I'll give you some references to where this is set out again in my skeleton argument. But that's also what Lord Mance was saying in the Welsh asbestos case. Then we get to the domestic approach. I'll take this very quickly because Mr. Allison had some time as well. But you see the same issues are being dealt with domestically. If we turn forward to page 2169, you see paragraph 151. You see that Lord Reid is dealing with there what he was identifying as defective reasoning in the court's earlier decision in the case of Humphreys. And again, entirely clear when you read that paragraph that what he's saying is about the position in respect of discrimination in respect of eligibility for welfare benefits, but it's actually instructive in this paragraph and in the next paragraph. What he's saying there is, even in that context, where the Strasbourg courts do take a bit of a hands-off approach, is that you can't mechanistically apply the manifestly without reasonable foundation formulation even in that context. And then paragraph 154, you see unsurprisingly that approach in Humphreys, i.e. the approach that he's just qualified, said needs to be qualified in the way he said, has been followed in other cases. And of course, those cases include paragraph 156, the DA case. So that is the summary of where we've got to. And then we get the conclusions. And this is what Sir James relied on, beginning at page 2170. But they are entirely limited to the specific context of Article 14. And when you read the sidelined passages, which I would invite you to do with care, not now because we don't have time, but the specific context of Article 14 and the policy considerations that I referred to at the outset, and the fact that you'd have to be a pretty unimaginative campaign group not to be able to cook up an Article 14 argument, and that these particular distinctions will usually have been front and centre of the debate, and there will have been extensive parliament, etc., etc., etc. They are the building blocks for the very large margin of appreciation that one gets in those cases. So my submission is, as I made at the outset, that when one looks at the approach that one has to take to fair balance in the A1P1 context, you don't look to this line of authority. It's dealing with an entirely different issue, with entirely different considerations. You look to the clear and constant Strasbourg authority that I took your lordships to, and which really we didn't hear anything about, and the what Lord Mance said about that in the Welsh asbestos case, none of which is gainsaid by anything that we've seen there. So it's simply not a case where one is required to take that approach. The reason why this is significant is because this was central to what Sir James was submitting. What he was saying is, well, here you have a context where Parliament has decided something must be done for good reasons of public interest. That is going to be the case in every A1P1 case. That is the structure of A1P1. It is a right that protects personal property. It's why it exists. It says you have property rights, they are to be protected, subject to the exceptions, and the exceptions are where you have this sophisticated body of case law that tells you how you apply that and how you strike the balance. So when Sir James says, actually in this context, look at what Lord Reid said, how can you possibly be in a position to apply some legal yardstick for how these lines ought to be drawn? The answer is, Parliament, by passing the Human Rights Act and telling you you have to apply convention rights, including A1P1, you have to have regard to Strasbourg case law. It's given you that yardstick because you've got it in the case law. And what it tells you, first and foremost, is that it shouldn't be retrospective, it should be foreseeable, it should be non-arbitrary, and where you are taking property away without compensation, that is going to be presumptively unlawful. And so when Sir James says we need bright lines, again, we don't quibble with that. The bright lines need to be drawn in a way that respects the way that Parliament, by passing the Human Rights Act, has circumscribed that freedom of action. So when Sir James goes to Mr Murphy's witness statement and says, actually, this is all part of a big scheme, you need to focus on those aspects of the big scheme, and you don't say, well, actually, we need to look at this particular feature that's objectionable, because forget about that, look at the big scheme. That is the wrong approach. It's absolutely what Strasbourg has told you not to do. So when we come to Mr Murphy's witness statement, Sir James confirmed, as I submitted yesterday, that it really comes down to paragraphs 144 and 145 of that lengthy witness statement, and not in my submission especially detailed or convincing statement of the policy there. All he can say is they are rationally connected and perfectly coherent. And so you can see why Sir James's submission is and must be, well, actually, this is where you apply the manifestly without reasonable foundation test, because that's what he needs to get home. But that's not the right test. You've seen what the right test is. And when you apply it, this is a breach of A1P1 rights. That only leads me, one last point I have to make about section 3. So James and I agree about the against the grain. You have my submission. It doesn't go against the grain. You've got those 2 paragraphs of Mr Murphy's witness statement. If these applied prospective only, none of the features of the scheme that Sir James said were integral to it will become unravelled. So we're simply not in the territory where you would be acting as legislators rather than interpreters if you were to adopt a prospective only interpretation. Again, the only point I would make is that while Sir James sort of invokes the constitutional danger of you acting as legislators, of course it's Parliament in section 3 that's required you to apply this approach. It's not a case of judicial overreach. It's a case of, as Gordon Mendoza pointed out, the court doing precisely what Parliament has instructed it to do. So My lord, I think I need to give Mr. Allison some time.
Sorry, yes.
Can I just clarify one thing? Towards the end of your submissions, you were saying that it's quite the wrong approach for the correct Strasbourg test to be applied, having regard to the scheme as a whole.
Yes. So what again? It's that it comes back to the lens.
Yes. So, is what you're asking the court to do simply to look at paragraph 9 then, and ignore the implications of your argument in terms of striking a balance for the rest of Schedule 8 and other parts of the Act?
If the court concluded that that was all that was necessary to render it compatible,
That's not my question. Are you asking the court only to apply the Strasbourg jurisprudence to which you've referred solely in relation to paragraph 9?
no, my lord. My primary submission is that the same approach applies to all of the paragraphs for the same reasons.
Well, I appreciate that. That wasn't my question. I'm sorry if I put it badly. But when we come to apply the test, you're only asking us to apply them to paragraph 9 without regard to any implications that may have for other parts of the legislation.
Well, that's so far as I need to go in this case, but I accept entirely, and I think all of us in the court accept that this is so the principles apply across all of the paragraphs that to which that's subject, and therefore, if the court feels it can't go any further, then it may be that those questions have to await for another day. So all Section 3 requires the court to do is to go as far as necessary as to remedy the incompatibility that's before you. But I would say that by parity of reasoning, exactly the same applies in all of those other cases. But if the court feels it doesn't have enough before in order to go that far, well then I can't ask the court to do that.
Thank you.
Can't do any better than that.
Mr. Harris.
My lords, I'm sorry about the time we find ourselves at, although in my defence, wonderful as it was to listen to, my low friend did somewhat go beyond the time and the timetable. I'm afraid I've got a number of points. I think many of them will be very short.
Yes.
And a couple of them perhaps will involve slightly more detail. There was one point from yesterday where from Mr Loveday suggested a dispensation application only benefits the landlord. I can probably take this fairly shortly, but in the Upper Tribunal's decision at paragraph 70, the President sets out there summarises quite helpfully the FTT's key findings of fact, which include, for example, the benefit of making sure you don't lose the right to enjoy public funding and so on and so forth. It's very important to remember that a dispensation application is not concerned with liability for the cost of the works in any real sense. The lessee's rights to challenge the expenditure are left completely unaffected. So if anything, a dispensation application is putting the landlord at risk because they can't turn around and say, well, we did ask you about this before, and so on and so forth. They are running the risk. So it's certainly not right to say there's not a benefit to leaseholders. Coming on to some points that came up this morning. My friend was dealing with why paragraph 10 is there, and one of his key points was to say, well, it brings it within the service charge machinery, giving the tribunal the ability to assess the costs. And he said, well, the important point is there that you have, where payments are taken from a reserve fund, those taking it from the reserve fund will not readily engage the controls over service charges, because the control is on the monies paid into the reserve fund rather than the money coming out of the reserve fund and being expended. I say that's wrong, and I say there's authority on that point, which was handed up, yet another thing handed up. It's the case that you hopefully have there called Esh Raggy and 7 to 9 Avenue Road, London House. It's a decision of the Upper Tribunal from 2020 of the Deputy President. And if I just, but one of the points that arose in that case was it was a challenge to legal costs that had been paid out of the reserve fund, and there was an argument, well, because it's come out of the reserve fund, no demand has been rendered to you for these costs, therefore the tribunal can't deal with it, and if it's a breach of trust, the tribunal can't deal with it. if I can just ask you to turn to paragraph 50 on internal page 12. And then 53. So there may be a relevant cost, which is a contribution towards an amount to go into a reserve fund. But that doesn't mean the money the reserve fund is then spent on isn't also a relevant cost. As I was saying yesterday, in accounting terms, you transfer from the reserve fund, treat that as income, and then you have expenditure being the legal costs, in this case, that they had funded out of the reserve fund. That is a relevant cost. So it can be challenged. So that shouldn't factor into how you read paragraph 10. Paragraph 10 is not there just to deal with reserve funds or to bring them within the tribunal's jurisdiction. Paragraph 10 is there for the reason it says it's there, which is to define what the term no service charges payable means. It's the shorthand. I think I'll leave the interaction between section 124 and paragraph 10 possibly to Friday afternoon, because I think we could potentially go around in circles. This point about the 2005 example, just by way of reminder, that arose yesterday in submissions, because the point is, if you read section 10.2a on its own, 10.2b on its own, and this is meant to have retrospective effects, the question is, well, if that's right, given that the tribunal can go back to the year dot in the right circumstances, does that mean that the legislation is saying that the landlords have to refund all this money on the 28th of June 2022? That's how it arose. It's no part of my case that that's what anyone intended. I didn't understand it to be Mr Loveday's originally, but it is now. I understand why, and of course the Secretary of State says, no, it says the Upper Tribunal said. The difficulty that you will need to resolve is that the Upper Tribunal's assessment, as Mr Loveday's assessment does, rests very heavily on the words in paragraph 9, no service charges payable, but to do so runs the risk of ignoring what paragraph 10 does, which is to tell us what that means and how it takes effect. Whether we describe paragraph 10 as a mechanism or a definition, one way or the other, paragraph 10 tells us how to give effect to it. And it does that by reference to costs incurred or to be incurred, not by reference to whether a debt is payable. And the problem with making it just referable to the word payable in paragraph 9 is that actually has a meaning in the Landlord and Tenant Act 1985 and the legislation, because that means the tribunal is considering whether a sum is payable, and it does that whether or not it's being paid.
And can I just, thinking around this for a moment, does your case on going back many years and dealing with the fire doors depend on B or on A or on both of them?
If the effect of paragraphs 9 and 10 read together is that it doesn't matter when costs were incurred, it doesn't matter they were incurred before the Act came into force, then if you make an application now under section 27A(1) as to whether a service charge is payable, if it's, this is one of the points I was about to come on to, because my learned friend submission would say, well, section 27A is inherently a retrospective jurisdiction, and therefore there's nothing the matter with that. I say that's wrong. I say it's not an inherently retrospective piece of legislation, any more than the High Court's inherent jurisdiction is retrospective, an inherently retrospective provision. Yes, it can look at matters in the past. But what we would normally say is, well, the tribunal looks at, say, the service charges in 2018 and determines whether the service charges incurred in that year are payable. And it would do that by reference to the terms of the lease and to the law. And it's not going, it will determine that according to what the law is now understood to mean, yes, but according to the law that applied at the time. Because unless a law specifically has retrospective effect, and I cannot think of an example in a landlord and tenant sphere where it does, the tribunal will always be applying the law as it was at the time. The difference in this case is if paragraph 10, 9 and 10 read together are to have retrospective effect, the tribunal is going to have to give them retrospective effect. So it's not that 27A1 is retrospective, it's if this law is retrospective, the tribunal must apply it. Because if this law says the service charge is not payable, and that includes in respect of costs incurred before the Act came into force, that's what the tribunal will have to apply. And that's an important distinction, because 27A1 is not inherently retrospective. The fact that, I mean, the courts every day deal with past matters. That's all they can deal with. They're not predicting the future. My friend did somewhat sort of take the bait of, I said, Sherrilambous is not a case that's in any way analogous. And I think, to be fair, what he says is, well, actually, it's an example of where fairness principles were applied, but he accepts the legislation is different. I just want to make sure we're clear on this. The Sherrilambous case, it's in, I don't think we need to turn to it, but it's in the authorities bundle, page 1553. It was that tenancy deposit case. And the landlord, it's really important to remember, yes, the possession, so there was a claim for possession, it failed because the landlord hadn't protected the deposit, the legislation came in later. But the landlord could have protected the deposit, the landlord could have refunded the deposit. The case says all this before serving a Section 21 notice, but they didn't. So they fell foul of the legislation after the legislation came into effect.
So it's not saying retrospectively you should have protected the deposit from the time you got it. It's saying once the legislation is in force, in one way or another, you have to comply with it.
You can't get possession unless you, and one of the options is simply to refund it. I mean, one wonders why the landlord in that case didn't just refund the deposit or protect it and start a new possession claims. It must have been quicker than pursuing the appeal. But point is, there's no loss of accrued rights. So in a retrospectivity sense, it's just simply not analogous. There was a point about saying, well, it's not obvious what's been lost at all because it's not obvious that the costs can be recovered under the lease and you were taken to the lease. Can I appreciate it's not really material.
That fits into the issues we have to decide. I mean, if it's not payable under the lease, it's not payable under the lease. Forget about all the issues that matter now.
Yeah, well, I think that's probably the short answer. Can I just say this? Paragraph 3.1, which you weren't taken to, paragraph 3.1 of Part 2 of Schedule 5, which is additional bundle, page 57, expressly provides for it. So you don't rely on, I mean, you could rely on the sweeper clause as well, but you don't have to. I don't quibble with the point that it's somewhat academic now we're all here, because the law has to mean the same thing in every case. My left friend gave an example of the difficulty. So I raised a point in my submissions that you have difficulties dealing with the balancing charges because you've taken sums on account. What happens to the balancing charge? Does it depend on whether you took too much or too little? My left friend gave the example of £50,000 and £100,000, and he said, well, if you remove, you're in difficulty if you have that temporal limitation, but you're not if you remove it. My simple answer to that is, if you have reference to when the costs were incurred, that addresses the problem as well. And really, his example illustrates the pitfalls of just focusing on the words in paragraph 9 without reading paragraph 10. it's a matter for you how you consider this legislation works. But what I do say is, if you focus on when the costs were incurred and take that as the cut-off, you have a very neat solution, because all of these problems are resolved and all of the unfairness is resolved. It's for you to determine whether that's what the legislation says, but it does, in my submission, at least resolve all of these difficulties.
Do we know whether in this case sums were asked for on account? We've not seen. Do we have the demands? No.
You don't have anything, because, and that goes back to what I said at the start of my reply. Section 20 dispensation applications don't concern liability. There's no consideration of liability. That goes to my point on ground one that paragraph 9 doesn't capture it at all. So you don't have that. No costs on account of, no sums on account of legal costs are likely to have been taken in 2021, I would imagine, because the budget would have been set in 2020, but you don't have the evidence in front of you. I know what the answer is, but you don't have the evidence in front of you. You do know when costs were incurred, though, because that's, or at least when a liability to pay the solicitors will have arisen, because obviously the proceedings were issued in 2021.
Well, that's when some costs were incurred, but costs incurred on the appeal to the Upper Tribunal,
well, they're no part of this case. Yes, and don't forget, we accept...
We're only talking about the FTT costs.
Yes, but also we accept the prospective application of the Act. That's not in challenge. And everything to do with the appeal is after the date of the Act. So, oddly, there's a very neat cut-off, because the tribunal proceedings end 2 days after the Act comes into force, with no work having been done by us in those 2 days, because we didn't know the decision was coming. So, it's just the FTT proceedings. This is a very brief point, but there's been a debate about when the explanatory notes were published. Mr Murphy's statement at paragraph 164C suggests they weren't published until July 2022. No date is given. We've done quite a lot of research on this. We say they were in fact made public on the 11th of August 2022. There is a date on the file name, if you download the explanatory notes, that gives some support to a 26th of July date was when they were maybe internally finalised. But I don't think there's a dispute between us and the Secretary of State that they were well past when the Act came into force. Well, the only other point I did have, there was a final point Sir James made about the explanatory notes, saying, well, they did go into detail in some aspects. My answer, that's quite short. Not in relation to the operation of these provisions, they didn't. They didn't go into that detail. They simply said they have retrospective effect. I agree they did in other regards, but that doesn't assist you. Unless there's anything else I can assist with.
I don't detect anything, and actually, you may not have finished quite at the 3 o'clock anticipation of the timetable, but it's within the court day. So thank you all very much for now. Some of you will be back on Friday afternoon, or at any rate at whatever stage it is of the triathlon case. So I won't suggest that we're reserving judgment now, because we obviously aren't. We'll resume on this case at some point on Friday. Thank you all very much.